How are you? Hello, hello, Facebook. Hello, YouTube. How's everyone doing today? So, for those who do not know me, my name is Ifama Odolami, immigration attorney from the Odolami Law Firm in New Jersey. We serve clients in all 50 states of the United States. And even though we're located in New Jersey, it's not a problem to assist clients who are in other states because immigration is federal law. So that allows us to practice in all 50 states. So I'm on YouTube, I'm on Instagram, I'm on Facebook. So I'm going to be looking up and down, just following the camera. So, how did you guys enjoy the Super Bowl? Wasn't that Rihanna? Didn't you do a great job? Yeah. So when you come in, please leave your comment. Tell me where you're viewing from, and then we'll get started. So I watched the Super Bowl, the halftime show, and guess what, you guys? You know Rihanna is from Barbados. She's an immigrant, just like me, just like you will be for those who are looking to become to get legal status at some point. So, like I said, immigrants make America better. Okay. So we do have a place here, and that's my passion and my mission is to assist you guys. So, hi, Ayodele from Lexington, Kentucky. Wow, Lexington, Kentucky, that's somewhere I haven't been. And Kende is from Atlanta. Nice to meet you, Kende. So, I have a really great topic, and when I finish, I'll answer some questions. Lily Gabriels is from New Jersey. Hi, Lily Gabriels. Thank you for joining. So, the reason I chose this topic is because I've had a couple of consultations about it. So, I thought to myself, even though I've done several videos about this, clearly there are people who do not know the answer to this question. So I figured that this is a good topic to go over again for somebody out there. So make sure you like and share and follow because it makes it, the different social media channels will put this up when you like, and follow and share. It's able to be more visible for those who are looking for this answer. So what are we talking about here, guys? We're talking about conditional green cards, right? So the cases that came to me were a couple of people who had conditional green cards and then they had filed to remove the conditions jointly with their spouse, and now the spouse is refusing to assist them any further. In one case, they got an RFE, which is a request for evidence, when USCIS is looking for more information. And when you don't respond to a request for evidence, guess what happens? Your case is going to be denied. So this spouse, knowing fully well that USCIS is asking for certain documents from him, decided, I'm not going to give it. And so that puts the intending immigrant in a bind. Like, what am I going to do? Because I know that we need to submit this document. Another client had they had fined their joint removals of condition, and now the relationship is gone to pits. So first of all, I'm going to go over certain things, that's certain information, so that you know what conditional removal is, and then I'll go over what you need to do. So let me say a real quick hi to Suleiman and Alaji. Thank you guys for joining in, and thank you for the people in Instagram and YouTube. So when you're married to a U.S. citizen or you're married to a green card holder, and at the time you get your green card approved, the marriage is less than 2 years, what you get is a temporary green card. It's only good for 2 years, right? So that's different from the permanent green card, which is good for 10 years, right? So if you have a 2-year green card, and you would know by looking at your green card, it would, give you a 2-year time span. What that means is that you need to remove the conditions on the green card 90 days before the expiration of that green card. And this is really important because if you fail to remove the conditions on your green card, you could find yourself in deportation proceedings, regardless of the fact that you've gotten a conditional green card in the past. Now, something that's important to know is that only a judge can take your green card from you. So sometimes your green card expires, and I have clients who get worried. What am I going to do? It's expired. Typically, this scenario plays out when they've filed to remove the conditions, and they're given an extension letter, and then the green card, has expired. So that when the extension letter comes, it's still expired. So they get nervous. So if that is the case, what you need to do is you need to make an InfoPass appointment. Take your I-751 receipt. I-751 is the form that you file to remove your conditions. When you file that, they give you a receipt. Take the receipt, uh, um, take your passport, go to make an InfoPass appointment, go to the field office and get an I-551 stamped on your passport, which renews it for another year. So now the extension letter is now 48 months as opposed to 24 months. And that's because USS is so backlogged and they really want to give themselves some time to do what they need to do without having to, continually send extension letters. So this is kind of good news and bad news. Bad news because it means that it could take up to 4 years. I hope that's not what it means. And good news because now you don't have to worry that you have an expired passport and, you have to go through the effort of going to make an InfoPass appointment. So that's by the wayside. So let's talk about people who have gotten their conditional green card and they file jointly to remove the conditions, and then their spouse is refusing to assist, or the relationship has it's broken down. So what you need to do, first of all, do not panic, because there are waivers that allow people in these situations. And I'll go through each of them one by one, right? So the first waiver I'm going to discuss is divorce. So USCIS knows that some relationships just don't work out. And it's not really the fault of anybody, it just doesn't work out. So if you are in that position where your relationship is not working out, don't stay in a bad relationship. Don't stay in a bad marriage because you feel like you must stay there to get your green card, because you feel like, oh, we already filed for, we already did the joint conditional removal, so I have to stay here until, until the case is adjudicated. That's not true. If the relationship is not working, regardless of the fact that you have filed to remove to remove the conditions jointly, you can file a divorce and you can update that joint removal. You can now tell USCIS, yes, we did file a joint removal, right? We filed jointly to remove the conditions. However, this relationship is not working anymore and we've gotten divorced. So in that case, I have a divorce decree and that's it. And at this point, what USCIS is looking for is the fact that it was a bona fide marriage. That you need to prove still that at the time you entered into the relationship, it was meant, you entered into it with good faith, with intentions of living and building a home with your spouse, a family, a life with your spouse. And so for that, you now have to supplement with the divorce decree. You have to supplement your submissions with documents showing that it was a bona fide marriage. So now, remember that when you got the green card, USCIS had a different stack of evidence. So when you're doing the I-751 waivers, they want additional evidence from the date of when you got your green card to the date when the relationship stopped working out, right? So typically in my office, we include the old evidence plus the new evidence because we want them to see, the flow of the relationship, right? And so if maybe after you got your green card, because a lot of times before you get your green card, there are a lot of things you're not able to do because you may not have a social security number. You may not be able to file taxes at that point. But at this point now you have, you've had a green card for a couple of years, maybe a year, whatever. You must have things that show that you guys have joint assets together, that your financial lives are intermingled. If you have a child, that's excellent evidence gold. Or you've purchased big item products together, that's great. If you've gone on vacation, or things that you do in your everyday life, there's just so many things. I always talk about this in my bona fide marriage video. So take a look at that to see the kind of things that you need to show. Now, the good news is this, guys. Listen to this. In the past, during the last administration, there was a policy to interview every conditional green card. There was an interview for every conditional green card, right? Now, If you provide compelling evidence, that interview may be waived. So that's a good reason for you to make sure that your application is really properly done, and done in a way that you're creating a map for USCIS to see how your relationship progress without having them figure out where things are. Okay, you want to make it easy for them to review. You want to answer the questions that they will be asking. Okay, now, so that's divorce. Now, remember that if you don't have that divorce decree at the time of the interview, if you're given an interview, they will likely deny the I-751. So it's important that you look at the timeline. So if you know that your green card is it's about to be expired, and this relationship is not working out, don't waste time. File for the divorce. Okay. Now, the second extension, the second waiver, is that of extreme cruelty or physical abuse, right? And like I've said before, there's so many different ways to prove abuse. So in the instance of a client who had a spouse who was working, they filed they filed to remove the conditions jointly. And then the spouse is like, you know what? I'm not going to do anything anymore. I don't care, right? Chances are, if you look through it, if you talk to that client, you will find other instances of abuse, control, refusal to assist the client because they're trying to get you deported, or they want to, they want to have their way. So there could be financial abuse, there could be emotional abuse, there could be psychological abuse, there could be verbal abuse. What is going on in this relationship, right? This is typical to like the VAWA case scenario, right? Where, we've talked about abuse, and it doesn't have to be physical. I say this all the time. It doesn't have to be physical abuse. You don't have to have a police report. You don't have to have hospital reports. There are different ways to prove abuse, right? I've gotten VAWA cases and I-751 cases approved without any physical abuse. So you need to know that your story is what you need to tell. What is going through? How is this? What are you going through? What is this person doing to you? How is this person making you feel? Sometimes they're kicking you out of the house. You have nowhere to stay. You come back, the locks are changed. They're trying to make you lose your job by coming to your job and creating, creating conflict, creating a scene, or they're leaving you in the house knowing that you don't have a job, you have no money. They're leaving you and for days without food, without any way to take care of yourself. Or they're driving in a way that puts you at risk of harm, such as maybe they're driving drunk. I mean, there's just so many things, that you can talk about. Everybody's story is unique to them. So the important thing is making sure that you can articulate your story in a credible manner, which is what USCIS is looking for. Okay? So if you're in this position where you're in a relationship, it's not working out, and there's abuse, you don't even have to wait 2 years to file to remove the conditions based on abuse. You don't, right? Because you don't have to stay in that horrible marriage. However, if you have filed a joint waiver with your spouse, and all of a sudden they're behaving, treating you badly, being extremely cruel to you, you can go ahead and update the original filing to add a new waiver, right? To tell the USCIS that you're no longer proceeding with the joint filing, joint waiver. You're now going to proceed on your own, self-petitioning, taking the waiver of extreme cruelty or physical abuse, whatever that is, right? So now the other two waivers, which you need to know about just in case, is death. If the U.S. citizen or the green card holder passes away, you can still waive the conditions on the green card, but you still need to show that it was a bona fide marriage. That doesn't go away. But I know that a lot of people really panic about having evidence. They're not sure they have enough evidence. And I tell you that we had a case where our client was just married. They'd been married for 3 months. They didn't have a lot of documents, and and we're still able to get her a green card. So there's always evidence that you're not aware of. So you need to talk to a lawyer and make sure that it's a lawyer that does this area of law, so that they can really, help you think outside the box to get you the evidence you need. So never think to yourself that I don't have the evidence, this is a lost cause. Talk to a lawyer. And we just got an I-751 approved, and we got a 5-star Google review from the client who said she had been to 4 lawyers who had not been able to assist, and then they came to us, and I talked to her. We went over the case, and I gave her a map. This is what we're going to do. This is how we're going to do it. And she got her green card, and she's over the moon. And because it'd been a while, because her case was delayed because of COVID, at the same time she's getting her green card, she's eligible to file for naturalization. So guys, there's a lot of good stuff that is available if only you know. So the last waiver would be extreme hardship. Extreme hardship. The only caveat is that the extreme hardship has to be shown during the conditional residency period. An extreme hardship is the only hardship that doesn't require you to prove a bona fide marriage. So what are we talking about when we talk about extreme hardship? Maybe in the country where the person is is from, there's war going on, or there's a reason why they cannot, if they were to leave the United States, they will suffer extreme hardship. So that's pretty much the 4 waivers. So important thing is, it doesn't matter whether the person is filing, your spouse is jointly filing with you, and you filed you've filed the paperwork already. If at any point that relationship is not working, you can update the filing to add a waiver. Okay? See? Nothing to worry about. So let me answer some questions, and then I will sign off. So Susan Kalechi says she's watching from Philadelphia. Hi, Susan. How are you? And then Alaji says, if you submitted your VAWA case to Vermont and later they sent it to Nebraska after your biometric, they sent your case back to Vermont Service Center, and they to speed up your case, what do you think about that? Honestly, Alaji, I don't really worry about what USCIS does with regards to where they're moving the cases, because they have their own internal reasons for moving cases. Sometimes it's to speed up the case. And as long as we've gotten the receipt and the case is proceeding within normal processing times, you're not going to get an answer from them why they're moving cases from Nebraska back here or back there. They're not going to tell you. But we have known in the past a lot of times they're doing this to make it, to speed it up. So it's really benign. Whatever the reason doesn't affect your case. Okay. And Susan says, I came to your office with my son the last time. Hi, Susan. I remember your name, of course. So I hope everything's well with you and your son. Okay. So I think that's pretty much. Let me see. There's anything I left, and then I will go. I think I pretty much talked about everything. Yes. So. Yep. So to make an InfoPass appointment, you have to make call the local field office, take your I-751 receipt notice and extension letter, take your unexpired passport, and go do it. So, all right, guys, it's a pleasure talking to you guys, and I will be with you again shortly. All right, take care. God bless. Bye-bye.